matter of Hirachand and Hirachand and others.
My lady, my lords, I appear on behalf of the appellant in this matter with my learned friend Oliver Ingham.
Yes.
And my learned friend Miss Constance McCall, QC, appears along with Sophia Rogers for the respondent.
Thank you very much. Now, just a little bit of housekeeping.
Indeed.
First of all, we had your alternative timetables. We would just like you to do it in the conventional way, please. We've all had a chance of both reading the judgments, obviously, and your very helpful scouting arguments and dipping into the various authorities. So, in fact, we think that the points, although very important, are actually not that long.
Then I will endeavour to live up to that, my lady.
I was somewhat surprised to see that we were going right up to the buffers, but you must, of course, take your own course.
Well, my lady, I will try and beat the time estimate.
Well, you must take it in your own way.
Indeed.
And we will propose to have just a 10-minute break for everyone at 11:30, and then in the afternoon also, but obviously not mid-sentence.
Indeed. Although I have said to my learned friend, if I need nudging, don't hesitate.
Yes.
As indeed,
yes.
I'm sure.
Now, so ground one, procedural irregularity.
My lady, yes. And my lady, as you have seen, this relates to a appeal against an order early in May, 7th of May, following a trial on the 24th of April. So very early on in terms of the pandemic and remote hearings. And I'll acknowledge that in terms of
I think that
the
is
trial
important.
judge's position, as everyone was grappling with the implications of the shift to remote hearings that we were needing to make. My lady, so far as the ground one is concerned, if you'll indulge me for a moment, can I just put this in the context of the Inheritance Act
Certainly.
and the procedure? If I can take you to ILOT, which is at divider 11 in the first authorities bundle.
Yes. We always have to refer to it, but I continue to be bruised.
My lady, likewise, my learned friend and I. It bruised a lot of people along the way.
I think it did, didn't it?
Indeed. My lady, given your indication, do you want me to give full citations and deal with the context in authorities, or shall I treat it as the court has notice of the head notes?
Well, I think we're all familiar with the head notes, but take us specifically to the passages.
In sections of the judgment.
Yes. Now, unhappily, the authorities bundle does not have tabs in it.
237.
And also, whoever didn't put the tabs in also didn't read the bit that says 350 pages. So we've got exploding bundles.
I'm sorry about that.
237
is the start, and I'm going to take you to the beginning of Lord Hugh's judgment, which is at 249.
Yes.
My lady, my lords, paragraphs 1 and 2 really set the context for the Inheritance Act, which is unusual in terms of its function so far as English law is concerned. He acknowledges that English law recognises the freedom of individuals to dispose of their assets by will in whatever manner they wish, and that there are default succession rules in the event of intestacy. That there is no automatic succession, such as happens in many jurisdictions, but that there is the exception to the general rule, a statutory system of family provision which imposes a qualification. And he describes it accurately as it has provided since 1938 for the court to have power in defined circumstances to modify either the will or the intestacy rules, if satisfied, they do not make reasonable financial provision for a limited class of persons. And I highlight that at the outset because we are dealing with a situation where a respondent to a claim, a defendant to a claim, if they are a beneficiary, is entitled, going into the proceedings, to certain property, assets, benefits. And they are brought to court because another party seeks to use the legislation to invite the court to use its powers to redistribute those assets. So it is not a situation of a claim against someone for a wrong. It is not a situation of a dispute about who's entitled to what. It is an invitation to the court, in certain circumstances, to overturn existing entitlement.
Well, what follows from that? If you've been debarred from participating, then why does it matter? Or what the underlying subject of the dispute is?
Because the court in those circumstances, and I highlight it at this point because it's really, we would say, the reason that these matters start as Part 8 claims and are dealt with procedurally a little differently, because the court still has to satisfy itself that it is a proper exercise of its powers under the legislation to interfere with what is otherwise the ownership of assets, property and the like. So you don't get the ordinary default judgment situation, for instance. We say that flows from the nature of the claim here. And indeed his paragraph 2 indicates key features of the operation of the Act. First of all, it stipulates no automatic provision will be made. Secondly, only a limited class of persons may apply. And towards the bottom of the page, third, all but spousal and civil partners who are in a relationship at the time of death can claim only what is needed for their maintenance and cannot claim on a general basis that it was unfair that they didn't receive any or a larger share or slice of the estate. As I've already referenced, under the CPR 5714 is the start of the section that deals with claims under the Inheritance Act, and by 5716(1), any claim under the Act must be made by issuing a claim in accordance with Part 8. There is provision in subclause 2 for combination of subclause 2 of 5716 and 5716(4).
Sorry, should we be looking at this? And if so, where is it?
I do apologise.
Page 487, weirdly.
In the White Book, page 2146.
487.
2146.
Fifty-seven 16(1) requires the use of Part 8. Subclause 2 provides for Rule 8, acknowledgement of service, 8.3, acknowledgement of service, and Rule 8.5, the filing of evidence to apply as modified in this rule. And those modifications, we can see over the page, we can also see at subclause 4 that the time for acknowledgement and service and written evidence is 21 days after service of the claim form. We then turn to Part 8 on page 524.
Sorry, you're referencing this all from the White Book. It's
I
not,
am.
not
I
in
do
the authorities
apologise.
bundle, is it?
It's not.
So you were about to take us to part 8.
8.4 on page 524. This rule applies where a defendant's failed to acknowledge service and the time period for doing so has expired. It says the defendant may attend the hearing of the claim but may not take part in the hearing unless the court gives permission.
Was this the only reason why the appellate was debarred? In other
The
words,
failure to acknowledge service.
Yeah, so,
Yes.
so it's by operation of this rule, is it, rather than a judicial determination
There's
in
a
the case?
I'll take you to the order in just one second,
thank you.
if I might, my lord,
Of course.
because it picks up on this rule and
Yes.
explicitly refers to the rule, which is
Yes.
why I'm taking it.
Yes, but what you emphasise, as I understand it, is the terms of paragraph 2.
Yes, may attend the hearing and may not take part unless given permission.
Yeah, so do you say that two things follow from that provision? The first is that attendance must be meaningful, not,
Exactly.
not theoretical.
And you must be in a position to either respond if the court is interested for
Well, I was
there
going to
to
say
be
this- I
engagement.
was going to say the second thing I think you submit follows from this express provision is that if the court is to be able to give permission and for that to have any meaningful effect, then you need to follow what's been going on so far.
My lord, that's the point exactly. And my lord, if we look in relation to evidence at 8.6, there's a similar provision. No written evidence may be relied on at the hearing unless it's been served in accordance with Rule 8.5 or the court gives permission.
I'm not sure what the relevance of that is. Was there any suggestion that anyone wanted to file written evidence?
My lord, if I can take you to the order, the debarring
Sorry.
order.
We had the letter, didn't we, which the judge read,
Indeed,
which was completely informal.
the manuscript letter.
So the order.
In the main bundle, behind divider 3, it's page 8.
But the date of this order?
The 21st of November 2019,
I'm sorry, which page is it?
8.
I don't have that at page 8, I'm afraid.
Not the core bundle, it's the
Oh,
supplement.
the other
Oh,
the-
sorry, it's supplementary. Yes, thank you.
It's the order of Mrs. Justice Lyven. It's in response to an application by the claimant. It refers at the third recital to the defendant having failed to comply with a direction to file her acknowledgement of service. So she had failed to comply in accordance with the rules, and there'd subsequently been orders for her to do so. And over the page at the top of 9, you see it is declared that the first defendant is automatically debarred from participating in the hearing pursuant to CPR Rule 8.4 and from relying on any written evidence at the hearing of the claim pursuant to CPR Rule 8.6. So
See, the
this is
solicitors there wanted to come off the record.
her
So
solicitor.
she had solicitors, she's failed to comply, she's got direction to comply, she fails
Failed to
again.
comply,
The solicitors say, we can't do anything, we want to come off the
and they
record.
come off the record.
That's the background.
That is my logic. And what the court has done is not imposing a sanction pursuant to an unless order. It has declared that the rules have had their effect. And explicitly, the rules that I just took my lady and my lordships to, that provide for non-participation but attendance, and non-participation unless permission is given, non-reliance on evidence unless permission is given.
Had Mr Justice MacDonald's direction specified what the consequence would be of not complying? Or was that just left implicit?
My lord, I have to say, it was left implicit. There was
Well,
no
she had
explicit
solicitors.
sanction.
She had solicitors at that point, didn't she?
She had
Yeah,
solicitors.
well, you wouldn't I mean, you'd expect the solicitors to tell the client what the implications are.
Yes.
Yes, I wasn't suggesting that
No.
anything follows from this. I just wanted to be clear what he'd ordered. Because if he had said in terms, then that might have made it even more surprising that she
Indeed.
didn't comply.
My lord, my understanding is that he made an order that extended the time for serving the acknowledgement of service and any written evidence. And when she did not do that, the court declared that the rules had had their effect from the failure to do so.
So just two questions arising, following on from that, please. First of all, what happened about the expert evidence that was ordered notwithstanding the failure to comply? That we see at paragraph 7.
My lady, that related to the claimant's position.
Yeah.
So far as I'm aware, it wasn't actually obtained. I've never seen any reference to it. I'm told by my learned friend there was an expert's report.
Fine.
My lady, you said 2 questions, I thought.
The other one was whether there was a subsequent case management order made to define the way the proceedings would take place in the light of the pandemic.
My lord, my lady, I haven't seen another order in terms of substantive directions. Clearly there was an order of some form that it would be dealt with remotely. But in terms of the directions for the trial, the order we have on page 8 through to 10, as I understand it, is the one that applies. And of course, that took matters up to witness statements and the like in January 2020, and the matter was coming on for trial in April. I think it was an instance of everything was proceeding as normal, and then at a fairly late stage a decision was made.
So was your lay client served with the notice of the hearing? Because obviously she knew it was happening, because
She did know it was happening. Bear with me one moment, my lady.
because the order we've been looking at doesn't fix the date.
No, it doesn't. My lady, at page 11, we have a letter from those instructed my learned friend, 28th of January. It encloses the updating evidence that the directions contemplated and says, without prejudice to the fact you've been debarred from participating in these proceedings, we write to inform you that the final hearing of your client's claim will take place, of our client's claim will take place in April. And encloses a note, which I think is the document on page 13.
That was very proper of those representing the claimant.
And my lady, you'll note that, of course, the order referred to the rules, and the rules provide that you can attend,
Which
and you can only
participate
with permission. The order didn't spell that out. This is written, no disrespect to the writer, as if you can't participate full stop without prejudice to the fact you can't. I'm telling you that this is the hearing, whereas in fact there was a right to attend. My learned friend may be able to help. Certainly there were various communications between her instructing solicitors and the home, the care home that the appellant was in. But I have not seen any order or anything that spelt out that she had a right to attend, and that there may be some permission, or the court had power to give permission to participate.
Well, I note at page 12, there's a letter which says in the second paragraph, this is a letter to her as I understand it, is that right?
It is.
Saying your solicitors will be writing to explain the effect of these orders as directed by the court. Now, would the solicitors be under an obligation to do that even if they
Indeed.
had been, I would have thought so.
And there is a letter in the papers that confirms that they did. I haven't seen the letter,
right.
But they wrote to confirm that they had explained.
But is it fair to infer that they might have explained to her that she would have a right?
They may have explained to her in a letter.
But is it reasonable for the court, to assume that the solicitors will explain the effect of the order?
It is certainly reasonable for the judge to assume that the solicitors will have complied with the direction that they write and tell her.
Somewhere along the line, she knew and it was sorted out because of course she had to be joined on the call.
She did, and that was largely helpfully down to my learned friends instructing solicitors who liaised with the care home in order to first make abortive attempts for there to be some without prejudice conversation. And then to send the link to email addresses for people working at care home.
Sorry, this is a query which I have no idea of the answer. I'm genuinely
Let's hope, my lord,
know.
that I do.
But if you have a case like this, let's assume, I mean, this woman was obviously in a care home and she was deaf. If she wasn't capable of participating or of understanding what's going on, within this case you need to have somebody to assist her since she's deaf. But would you expect the solicitors to tell the court that? I mean, I'm just not sure what happens in those circumstances. You know, where the solicitors are dealing with somebody, they think, well, we can't get any sense out of her. We don't really know what to do. I would have thought, but I may be wrong, that before coming off the record, they'd explain that to the court. And the court would try and find a solution to the problem, as it were. What do you do if this woman isn't really capable of participating in any way?
Well, my lord, obviously it depends on how much they know, whether they've simply had no response, and what they know of these circumstances. One might expect them in their evidence to reply to come off to indicate what they know.
Have we got that statement in the bundle?
I haven't seen it.
It is in.
Oh, I do apologise.
Yes.
My oversight. Page 296.
It's the statement of Stephen Ingle, the
296.
claimant's former solicitor, and behind it there are a few letters between him and the claimant, which you exhibit.
Grateful to my learned friend.
Did anyone think about having an assessment of this lady's capacity
I'm not aware. My lord,
in the light of that statement from the solicitor?
my lady, in terms of the current legal team, we did, as it were, after the event for the purposes of the appeal, and were satisfied that we could act and take instructions. I'm not aware of anything being done in the context of that period of time of trial.
Malena Jr. informs me that at the November 2019 hearing before Mrs. Justice Leven, she was informed that the solicitors who were until then acting for the claimant thought that she had capacity to litigate.
Thank you.
I'm sorry, I missed the end of it. She was told what?
I'm sorry. She was told that the claimant's then solicitors considered that she did have capacity to litigate.
Right. And that was not these solicitors, that was an earlier set.
That was an earlier set, Vickers and Co, who acted for her from January till November 2019.
Right.
So that is the solicitor who's made the statement on page 296.
Yes.
So what would the court's position be if they have evidence from the solicitor who says, a solicitor who says, I don't think she's capable of participating in these proceedings? What would the court be expected to do in the normal way?
Well, my lord, there was no suggestion that she lacked mental capacity. the difficulty was that her situation and her disabilities were such that there was clearly, even without the intervention of COVID, significant difficulty in her engagement with the proceedings. And we can see from his witness statement, the solicitor refers to her being deaf and elderly, to efforts being made with people at the care home to facilitate things, and that being very much dependent on them assisting in terms of taking her back to the property to look for
Are there similar rules or provisions by way of practice direction or otherwise that would amount for a participation hearing in the same way as would happen
In
under
family.
the family proceedings rules?
No, my lord.
I mean, any court that saw the solicitor saying that the way he took instructions was trying to type onto his screen for questions for her, and having received a statement saying she clearly needs assistance and she can't do it, for debarring her would be looking for the very minimum of having an interpreter.
Indeed. I'm not aware of there being any equivalent. I think it's fair to say that in both family and crime, things are much further ahead in terms of more formalised structures that address the needs of vulnerable parties, participants, witnesses, whatever.
So none of the vulnerable
No.
witness, participants, litigants provisions apply in civil proceedings, in Part 8 proceedings.
I've certainly had situations where I've looked to what the family guidance is and invited the court to consider taking on board some of that, but they're not formally part of the CPR. And I think, and my learned friend practices as much, if not more than me, with vulnerable adults. I think it's fair to say that in the civil courts, ordinary civil jurisdiction, there is not a lot done to address those concerns in the way it is done in, obviously, court of protection, but family and crime as well.
It's not even necessarily in the court of protection. I mean, that's deafness doesn't leave you incapacitous. It just means you can't hear. And
but I think
excluded.
also the court of protection is more used to there being other people who are taking part in litigation who may have vulnerabilities of various sorts and disabilities of various sorts.
But you're not complaining that the judge should have taken steps to deal with her as a witness who has lacked capacity or anything like that?
Not as someone who lacked mental capacity, but as someone who faced significant barriers in her ability to attend in any meaningful way, to follow in any meaningful way what was happening, and therefore potentially to participate with the permission of the court, either at the instigation of the court or at her own instigation, if it appeared there was something that it might be appropriate to seek the court's permission in order to do.
Yes, you don't and you can't complain that she was debarred from participation.
No.
That's a given. It may be, I don't know if it's helpful, it may be helpful just to understand what the applicable principles may be if we first envisage the scenario where we were not in the lockdown, so we were just in an ordinary court hearing situation.
Indeed.
Like this one, as it were. Can you help me? What should happen?
My lord, in those circumstances, if no one else was doing it, I would anticipate the court would ask the various agencies that provide support to participants whether there could be someone in court to assist, and that would then be someone who had some familiarity with the court process, would appreciate that it was perfectly possible to ask the court to wait whilst they explained something, would have a greater or some understanding of what might be particularly relevant for the vulnerable participant to actually contribute, whether in response to questions from the court or whether because something was being said where it seemed like there was a gap that she may be able to assist with, for instance. It would also be apparent to the court that she was present. Probably more likely in those circumstances, the court would be watchful of explaining things to her, even though she was not an active participant. Generally, courts where they have litigants who are not represented are very careful to ensure that those participants, those people, actually follow what's going on as far as is possible without halting the process too much.
But does the court have either the power or the duty to pay for such a service if it's not otherwise available to the person concerned?
My Lord, I don't think I can say the court has a power to pay for it, but for instance, in this building, there is the PSU that provides support free of charge to people who need assistance, and that's support from people who have some experience of litigation and of working beside people to ensure they are following what's happening and to fill the gaps of the unfamiliarity. In this context, obviously being someone who's deafened, it may have been appropriate for the court to ask the PSU or the CAB that works out of the court to see whether there was a charity that could assist in terms of her as a deaf person in the court, or to look at the facilities that the court itself has.
Because I presume, because she'd been debarred, that any power the court had through those directions to either provide for perhaps even the civil courts, even do the intermediaries, do they? No? Okay, no intermediaries. But interpreter.
Sorry, I was just going to say to my lady, I've never come across it in civil context.
Okay. No intermediary, but interpreters, presumably, even in civil.
Indeed, absolutely.
And the court would ordinarily, that would be...
And there's the hearing loop mechanism. There are a number of mechanisms.
That would be paid... My question really is, if she was participating, then the court could make an order that the interpreter was ordered to attend, to be there for. And as my understanding is, and you'll all correct me if I'm wrong, that isn't an issue that goes to legal aid. That's paid for by an HMCTS, I think.
That's my understanding as well.
So if she was participating, then that's an order the court could, and you would say should, have made. But presumably, when she's been debarred, that's not.
My lady,
it can't be argued.
I'm going to hesitate slightly and say I haven't looked at the rules around payment. Given that she had a right under the rules to attend, I can't be sure. I suspect that funding wouldn't be made available, but I'm not going to concede that point without having.
Well, it would be logical.
I should have checked the rules.
What are you exactly? Sorry to interrupt.
Sorry, my lord.
What are you exactly saying the judge should have done here?
That just anticipates where I was going, my lord. What appears when one reads the judgment is that having established that she couldn't hear, that she was connected, that she had someone from the care home who was connected and listening and would write notes. The hearing then, in fact, proceeded pretty well as if she wasn't there. There are a number of points in the judgment where it is indicated that information was provided by the other defendant, her son, or he said he couldn't provide information about her. There is no indication that a request was made to the care home worker who was sat with her to ask her a question if information was being sought. It appears that there was no effort, and we weren't present, and our client couldn't hear. So I will be corrected by my learned friends junior if I'm wrong about this, but there is no indication in the judgment that any effort was made to establish whether the care home worker understood even what the claim was about, understood the role that they were apparently taking of being a conduit for relevant information to enable the appellant to follow, and that if appropriate, to pass information back to the court.
Sorry, I don't want you to be in. If you haven't finished, please do.
I was just going to say, as a care home worker asked to sit there and take notes, one might simply assume that all you were doing was that, sitting and taking notes in an absolutely passive way.
Yes, thank you. Speaking for myself, at least, I do find it helpful just to divide up the issues and consider first what should happen if it's all in person and we didn't have the pandemic, and then secondly to ask what difference did it make that we were in the middle of a pandemic and it was done remotely. So if we're in this ordinary courtroom scenario and the judge is aware that this person is not entitled to participate, is entitled to attend, he can see her, she's in court, she seems to have somebody with her who's sort of apparently explaining from time to time what's going on and is writing notes and so on. You seem to be suggesting that the judge has a more proactive duty to find out who are you, what professional qualifications do you have, can you really competent, do you understand what this case is? I'm just wondering, that may be right, but is that really what the judge's duties are?
My lord, I would suggest yes. The ability to attend must be for a purpose. It must be meaningful. And the court does have duties around the access to justice and the barriers that are faced, for instance, by disabled people. She was a party. She was entitled to be there. The hearing was about things of significance to her. The purpose of her being there was so that she could follow and understand what was happening. Added to that, there was the potential for permission to participate if appropriate, which is a particular purpose for attending and being able to follow. And the court always seeks to ensure that its process is understood by those who are parties to it. Obviously, that has to be kept in balance, but, my lord, if present in a hearing, one might expect that the court would just inquire who the person was, and if they understood what the context was, what their role was, what they were there to facilitate.
As to the question of answering questions from the judge, oughtn't we to assume that the judge felt he had enough material to decide the case? Perhaps if he felt there was anything critical he should ask her, he would have done it. But he had the assistance of the son, he had her letter, and he had lots of factual information about the estate from which he was able to give a fairly accurate, one might have thought, assessment of what the funding was in this case, which is critically, and he knew her own requirements, which were essentially the care costs, and not much else, as he pointed out. I mean, you can't criticise a judge because he didn't ask her anything, can you?
Well, my lord, what we see is the judge says he doesn't know if she has other money. The claimant thinks she has other funds. The son said he didn't know.
But that is, I'm afraid, one of the consequences of being barred. I mean, if she'd just not turned up, the judge would have had to get on with the case single-sided. Surely the more relevant point is your point that it has to be meaningful attendance, and she was there, and it was common ground that she was extremely deaf.
Indeed.
And so surely your perhaps better point is that provision or consideration should have been to seeing if something could have been done to ameliorate that, so that her participation could be, her attendance could be meaningful.
Indeed. That is the primary point.
As my lord says,
Well,
you can't start expecting the judge just to treat us if she's a litigant in person participant. I mean, that
I
couldn't be appropriate.
I quite accept.
The critical question may be, how far should a judge go in those circumstances to assist somebody who is not a participant now, but is present? How far should the judge, for example, have adjourned the case and advised her to get somebody to translate for her, to use sign language or whatever? I don't know how they would work it if she didn't understand sign language. But how would one, in practice, deal with the point so that she would be able to understand what's going on?
To take my lord's approach of, if it was in person and the court felt that someone may well not be able to follow what was happening and where they were a party and entitled to be present for meaningful attendance, then one might expect the court to adjourn briefly so that the agencies that are available at court could speak to the individual and ascertain whether they could manage or whether anything could be offered by those agencies.
Well, that would be a sensible approach, but how long would you have to adjourn for here?
Here, the difficulty was obviously enhanced significantly by the fact that the pandemic was forcing the court to look at remote hearings. Here, the court had to make a decision whether a remote hearing was appropriate and whether at that point in time that remote hearing could go forward. The effect of the hearing being remote was inevitably the court was at a significant disadvantage in being able to ascertain whether or not the appellant's attendance was meaningful. It couldn't see and
But no, I'm sorry, right in the first couple of paragraphs of his judgment, the judge makes it absolutely clear that he's completely cognizant of the difficulties. So it didn't make a blind bit of difference whether this was remote or in person.
Well, my lady, what
you may say he should have done something, and I understand your point about that, but I'm afraid I can't see your point that says it was different because it was remote, because he was very clear what the problem was.
He was clear what the problem was. He concluded that having someone from the care home there taking notes was sufficient. What he could not see in quite the same way that you would do in an in-person hearing was whether that was working or not. So he was at a disadvantage, and certainly so far as the appellant was concerned, with her particular disabilities, the moving of it onto a remote hearing would exacerbate the inability to actually access and follow what was going on.
But can I please ask you to come back to my lord's earlier question? In the circumstances which this judge faced, what do you say he was required to do, and how long was he required to adjourn for?
My lord, we would say he should have made inquiries, adjourned it and made inquiries about getting some support in place from someone who understood proceedings and could actually bridge that gap and give meaningful support if it was going to be necessary, as we now know, obviously we didn't know at the time, to look at remote hearing because of how long the pandemic is.
But are you contemplating later the same day or many months into the future?
Realistically, with all the practicalities that were being faced by everyone at that point, it wouldn't have been later the same day in order to ascertain if there could be someone available.
But it's very difficult, isn't it? I mean, the judge has got to deal justly with the case in front of him, which includes the interests of the other party before him. And I'm just wondering how... I can well see, we all understand that it was less than ideal. actually to have remote hearings was probably less than ideal.
Indeed.
But we had to cope. And I think the threshold you have to cross is to persuade us that actually what the judge did was not reasonably open to him. Is that right? It was unfair.
Yes, my lord. That it was unfair given the challenges that this appellant had.
Well, I wonder whether there's a difference between what a judge would be desirable to do and what a judge has a duty to do. See, if people are in court, I can quite understand that it makes sense for a court to say, we've got some agencies present. Before we go any further, let's see if the what they call witness protection people or possibly the CAB, or they've got any idea how we might improve matters. But we are talking about somebody who I accept it's all very uncertain as to precisely what she can understand. But if she can't understand anything, then following it is not going to be realistic. And you say she has some kind of mental capacity in any event. Now, how far is it not unreasonable for the judge to say, well, here's somebody who wants to hear what's going on, wants to follow it, who has some basic mental capacity. How far should the court anticipate what she will need, and how far is she under an obligation herself? Of course, I appreciate it's more difficult for a vulnerable witness, but how far can the judge say, well, I would assume that if somebody in that situation wants to hear what's going on, they will find whoever it is that they need to make that a realistic event, as it were. I mean, there must be limits to how far one can expect the court to act for people, particularly when they're not under an obligation. They've got no power to require her to do it and got no power to pay for it.
Of course, there must be a limit, and it's a balance to be struck. But this was very early on in the pandemic, so we can, and again, Marlena Friends Jr. may be able to help with how shortly before the hearing it became apparent this was going to happen as a remote hearing. But it appears likely that it was fed, and certainly at the time, most hearings, decisions were being made very close to the date of the hearing, whether they would go ahead or not, whether they would move from what had been originally listed as an in-person hearing to a remote hearing. That is happening very quickly. That gives much less time for anyone to really work out what's going on, and this would have required her to understand discussions with people in the care home to work out what support was going to be needed.
As I understand it, this lady suffers from age deafness, as opposed to some sort of genetic birth deafness.
Yes.
So the reality is that, as I understand it from what I've read, is that this is not a lady that uses sign language. And so a conventional deaf interpreter that we see being so skilled in these courts frequently would have been no benefit to her whatsoever. So the reality is that, given what we know about her, and I don't think it's in dispute, that the only way that information could be passed to her would be by way of notes.
Indeed.
And are you saying that where her role was only to attend rather than to participate, the judge should have had breaks every 15 minutes for them to catch up?
No, the crucial thing is whether the person who is listening and is therefore the source of her information about what's going on has any ability to actually do that effectively or meaningfully.
We don't know one way or the other, is that what you're saying?
Yes. And the court appears not to have given consideration to whether the simple fact that someone who works in the care home is sat with her and can write notes. You know, the reason the court has the agencies it does located in its buildings by way of the CAB and the PSU is because it's an alien environment for people, and therefore if someone is going to assist a party, they have to have some understanding of what is happening, how to deal with matters.
Just remind me, but how was the dispute as to whether she did or did not have the papers resolved?
My lady, it appears that the bundle was sent electronically to the care home.
Well, no doubt she was an expert on her Mac.
The letter, the handwritten letter she wrote, which was a couple of months before the trial bundle was sent, it was dated the 31st of January, although it was only sent by the care home manager just before the trial, refers at that point to her having lots of paper and not really being able to manage it. That, if one looks at the chronology, appears to be a reference to the updating witness statements that had been sent through.
Certainly the solicitor's letter indicates the sending of some statements which I presume were in hard copy.
Yes, at the end of January, and then her letter is dated the 31st of January. So she seems to have struggled with the hard copy, and the only reference I can see is to, and indeed the solicitor says, again, absolutely understand, given all the difficulties we were having, that the bundle was being sent electronically to those emails of the two people working at the care home because of the concern about COVID on paper.
Where's the, just give me the reference to her struggling with the heaps of
It's in the main bundle, divided 12, page 45.
By that, do you mean supplementary?
Yes, sorry, large bundle.
Divided 12, page 45, thank you.
I hope I've given you the right page reference. So 45 is a telephone attendance note. Between those instructing my learned friend and someone at the care home, Hansa Manon, and he explains he'll send through the bundle electronically.
It does seem that Ms.
And then
Robinson
on page
went,
48.
it would appear that Ms. Robinson went the extra mile in trying to facilitate.
Yes, until she hit the blocks at one point and said, we just can't deal with this. But that was between the trial and the judgment. But yes, certainly, given everything they were dealing with. So page 48 is the actual sending of it.
Oh, I'm sorry, I've just realised it's 25
I'm
to time.
very conscious of the time.
So I do apologise. Perhaps we'll, should we resume at 1:45 or just a moment past?
duty.
The only problem is that what they'll probably say is relates to sign language interpretation.
Yeah.
So maybe that's why. Because they say quite a lot about what the judge should do or should do.
Translation. But they're there already, aren't they?
Oh yes, yeah, indeed. So apart from that, no.
Mm-hmm.
We've just had a note through from Lucy, who's sitting and watching, saying that they can hear our discussions. So just with that in mind. Nothing too controversial said, I don't think.
No. Hmm? Try and get back on track.
So it's the way they're
We just can't plan.
Yes,
my lady, my lords. Can I just invite you in this context to look at in re C in due course. I'm not going to take you to it now. Paragraph 18. It deals with the particular context of those who are deaf or deafened. It's divider 16, page 329 is the start of in re C, and paragraph 18 is on page 332. I appreciate and accept that that case involved an active participant, but it is helpful in terms of highlighting the bridge that needs to be built in order to enable someone, we say, even to meaningfully attend, and the court's role in that. Then moving on, my learned friends rely on time travel against Pakistan International. That is in the Authorities Bundle Divider 6. It starts on page 170.
You want us to turn that up?
My lady, please. It's a decision of Mr. Edwin Johnson, who's sitting as a deputy of the High Court. And he gave detailed consideration to what the principles around debarring orders are and what that leaves in terms of what a debarred party, I can put it at the highest level, might still be able to do, and the court's position in that. And he summarises his conclusions, having gone in great detail through the authorities at paragraph 55. And we submit that that supports our analysis about the need, given the order made in this context, which incorporated or declared the automatic bar against participation, set with permission of the court, and ordered the allowance of attendance, that these principles are entirely appropriate and should guide the court. So 1, he says, if there's a debarring order in place, its effect depends in first instance on its terms. In this instance, the effect of CPR 8.4 and 8.7. One must consider the terms in order to determine what it debars the relevant party from doing. Then he says that where an order debars a defendant from defending particular proceedings, it should mean what it says. And we do not suggest that the court had to go so far as to facilitate full participation because she was debarred. We accept that the court, in looking at the fairness here, will take account of the reduced role that the appellant had as a result of that order. At 3, the case law does appear to demonstrate the existence of a residual discretion or trial management power to permit a debarred defendant to take some part in the trial of the relevant proceedings. It seems to me this discretion is a narrow one. In particular instances, I can see the exercise of discretion might include the permitting of some limited submissions or some cross-examination. More generally, it strikes me that a debarred defendant should normally be able to address the court as to the form of order made after the substantive decision on trial and in relation to pointing out any errors in the judgment. And it strikes me that I say this strictly on a provisional basis because it's not a matter I'm deciding at this stage. It does strike me a debarred defendant ought to be able to address the court on the question of the costs of the relevant proceedings. But I repeat, that's not a question I'm deciding in this judgment. So that's aside from the terms of CPR 8.4 and 6. he concludes, having, and I invite you to look at his analysis of the authorities, that there has repeatedly been suggestion that the court can, in the instance, give permission for a defendant and the authorities. Some are debarred from defending, some are debarred from participating. But the court has that residual discretion, and that must be right, pursuant to the overriding objective and the need to do justice. Things develop in litigation, and there must be a power of the court to say, actually, you're debarred, but for this purpose, this limited purpose, it's right that I allow you to do X or Y. But in any event, we're in a CPR 8486 situation which does that. Again, he reiterates at 4, the overriding principle, however, must be that debarring orders should mean what they say. The debarred defendant should not normally be permitted to participate in a way which undermines the order. Here it's not an order, it's a declaration as to the effect of the rule, but I would accept that's the same. But of course, the fact the court has power to give permission means that there would be many things that were not in any way undermining that provision if the circumstances arose. And then he highlights at 5 that the fact that there's been an order debarring doesn't mean the matter goes into default. And we say all the more so in an Inheritance Act context where the court has to be satisfied that it's appropriate to exercise its powers and how it should do so in order to redistribute the wealth.
In the present case, do you place any reliance on what happened in relation to costs?
Yes, we say that is exactly the sort of situation where it would have been appropriate for the court, contemplating what was an unusual and we say harsh order.
Can you just forgive me for interrupting you, but just so I can be clear on the chronology, the judge didn't deal with costs at the end of the substantive hearing? It was later on, wasn't it?
The submissions in relation to making provision by way of an award for the uplift was dealt with at trial.
Oh yes, yes.
And
yes.
dealt with ahead of.
Certainly.
And certainly we say at trial it would have been appropriate and should have been the case that the appellant was permitted to participate.
I know that's going to be another part of this appeal. That's the other ground.
Indeed.
But it might.
But at that point, the two cross.
I understand that, but what I was really asking about was the costs of these proceedings, and just remind me exactly what happened and when in relation to the costs.
At the hand-down hearing on the 7th of May.
Yes, that's what I thought.
At that point, the court dealt with the base costs, if I can put it that way, as opposed to the uplift, and made a summary assessment of what were claimed just short of 85,000 in the sum of 80,000.
That's what I had in mind. Now, was your client, on your submission, was your client enabled effectively to deal with that discrete element of the proceedings? In other words, the costs order that should be made?
She was provided the day before by emails to the care home with some information, the cost schedule, etc. They were all sent to the court and then separately forwarded to the care home, and the care home sent a letter in response.
Yes, but do you say that the judge
should have
was required to do any more than he in fact did in relation to the costs order?
My lord, we would say that's exactly a situation where she should have been invited to participate and address the making of that cost order. And indeed, at the trial, the inclusion of the uplift and treatment of it as part of the award.
I don't see why you say a judge should have asked her about that at trial. She's debarred from the proceedings. She has no right to take part in the proceedings. If the judge felt it was something that he would be assisted by, or if he felt that he couldn't reach a fair decision in relation to the uplift without dealing with getting information from her, perhaps he would have felt in those circumstances he should ask it. But it can't be said that he gave a particularly generous, if one allows the uplift, it wasn't particularly generous, as it were, in the claimant's favour. I mean, why does she have a right, having been debarred from the proceedings, to take part in that part of the proceedings as of right?
My lord, we would say in a situation where there is conflicting authority,
this is wholly unrealistic.
conflicting decisions.
I'm sorry, this is
a
unrealistic, isn't it?
Sorry?
It's not a conflicting decision. This woman would not be in a position to talk about the legal rights or wrongs of these decisions. Surely that's not your point, that she should have had an opportunity to make legal representations.
My lord, in a situation where the proposal was to make an unusual order with the law around it unclear, then we would say it should have been flagged up that that was something where the court needed proper assistance.
Well, she couldn't give it.
She couldn't.
So
So
what
she
are you
might
saying?
not then have set about getting assistance in order to do that. But the message that she had been receiving in every communication after her solicitor's letter was, you can't participate here, and just able to watch such as she could see.
That will often happen to someone who's debarred. There'll be a legal issue, and they're debarred from participating. That's the name of the game.
My lord, I hear what you say.
Where do we find this letter that was sent by the care home, please?
Bear with me just one moment. It's in the supplemental bundle. Uh, 103.
Thank you.
And the documents that were forwarded, if it helps, to the care home manager that led to that communication are at page 76 to 80. And she initially responds, the care home manager.
So just give me a moment. I'd like to just have a look at this letter.
one last page, my lady, the response to receiving pages 76 to 80 from the care home manager is at page 81, at the top of the page.
Sorry, page?
81. My lady, my lords, unless there was anything else so far as ground one is concerned, my junior has been trying to check out the position so far as assistants and exactly what the terms are, and we'll look at that over lunchtime.
What I'd just like you to tell me is, what do you say should happen?
Should happen now.
If set aside ground two for a moment, I mean, we have the position where permission to appeal was refused on the substantive outcome of this case.
Indeed.
So it follows, therefore, that the judge was not outside his bounds of his discretion in making the award he made. In the circumstances where she was debarred. So if, as you suggest, there was some procedural irregularity in whatever form, what do you say the consequences of that should be on the facts of this case, and given that permission to appeal was refused on all the other grounds?
Indeed. My lady, our first position, primary position, would be that the trial was an unfair trial, a mistrial in those circumstances, and should not be allowed to stand. But, my lady, one has to, and I have to accept, put into the mix the position in terms of the bar against participation, save with permission, and in line with the Times Against Pakistan decision, we would say that it is appropriate to look at the situation where the court really should have facilitated participation by and allowed participation by the appellant. That email that you just looked at, the court just looked at on page 81, makes it clear that there was real concern from her, despite the difficulty she was having and the fact that the care home was able to give her even less assistance by May than they had previously, about the possibility of cost consequences, and that really at that point, if no other, the court should have given her permission to participate in the arguments about costs.
You still haven't told me what you say this court should do if they decided there'd been a procedural irregularity. Retrial of the whole thing? You've not got permission against it in relation to the substantive order that was made.
No, my lady. I think what I'm trying to say is to retrial the costs and the CFA uplift issue. So all of the costs issues, on the basis that that at the very least should have been the point at which she was permitted and facilitated not just to attend and follow, but to seek to be actively involved.
Thank you.
And indeed, that email on page 81 indicates a real anxiety around that, which, had she been able to follow and understand properly what her position was, should have translated into a request to the court for permission to engage around those issues.
I'm still not clear what the relief is you're seeking. I'm sorry, maybe I'm just not very clear. You don't want the decision to be that the decision doesn't stand and it goes back afresh.
That's your primary.
That's our primary position.
That is what you do want.
But
I thought you were saying notwithstanding. I'm sorry, I misunderstood.
That's
I
our
thought you said
primary
the costs
position.
would be out of all proportion, which they wouldn't.
Our primary position is that it should go back.
I'm sorry.
My lady rightly makes the point that the challenges to the substance in respect of the other elements of the award were not given permission, and in those circumstances, recognising what is likely to be the attitude of this court to that, then the alternative position is that the costs should go back, unless this court deals with them.
Thank you. Round 2.
Round 2.
Or ground 7 or 19 or whatever it was
Indeed.
originally.
So we are concerned here with the meeting of costs and the award. If I can start with the Senior Courts Act, which is in the Second Authorities bundle towards the back, page 523. It's divided 4 in the statutes section. Section 51 provides that the costs of and incidental to all proceedings for these purposes, the High Court shall be in the discretion of the court. And then there is the power to make rules, which are contained in the CPR. Such rules may make provision for regulating matters relating to costs in those proceedings, including in particular prescribed scales paid, or securing the amount awarded to a party in respect of costs to be paid to him, such representatives is not limited to that payable to him if he had not been awarded costs. The court shall have full power to determine by whom and to what extent the costs are to be paid. And then it goes over the page, and for instance, Supplement 6, there's provision for empowering the court to make wasted costs order 6 and 7, etc. So it's the broadest power in relation to any costs incurred in connection with proceedings, and would plainly, and did until the introduction of the bar on recovery of uplifts, include the uplift on CFAs as well as the base costs that the uplift is calculated by reference to. We then have at divider 1 in the statute section, page 483, Clause 58A of the Courts and Legal Services Act 1990, which introduced the bar on recovery of the uplift on CFAs, which had hitherto been possible, so that a claimant could be on a CFA and recover both their base costs and the uplift from their opponent. And it's subclause 6. A costs order made in proceedings may not include provision requiring the payment by one party of all or part of success fee payable by another party under a conditional fee agreement.
Is it significant that that uses the phrase a costs order?
My lord, you keep taking the words right out of my mouth. Costs order is not defined in either the Courts and Legal Services Act or the Senior Courts Act.
Well, that may be right, but we all know what a costs order is, don't we?
Well,
An order for costs.
an order that provides for what is going to happen to costs. So it may be an order that provides that one party pays a sum of money that reflects or relates to the costs of the other party. It may be that a lawyer pays a party's costs of proceedings, or some of them. It may be that there be no payment. My lords, my lady, in our submission, it is simply an order that relates to or deals with costs that have been incurred in proceedings.
Is there a definition of success fee?
Not that I've got in front of you. I might have to check that over.
I think I'd be grateful
lunch.
because question is a success fee costs.
My lady, we would certainly say it is, because until you were no longer able to recover it, it was dealt with fully through the cost regime.
Okay.
So the CPR, the power and the rules relating to the making of orders relating to costs, could deal with both the base cost and the uplift.
But a decision had been made by Parliament to strip them
Subsequently,
out, to separate them out.
To say that that's no longer possible.
Were they in the, before the, I'm sorry, I'm sure everyone else in the room knows all this, but pander to me, before the change in the rules and the bar came in, was it called a success fee in the?
Yes.
It was called. So it's always
Yes.
been identified by reference to being called a success fee.
Yes, and that's generally in the contract.
Yep.
It is the CFA.
Oh, well, I knew that, but I was wondering whether in the original rules it was still called a success fee. I mean, the original.
So far as the rules.
The original Act, I mean, don't I?
Yes.
Before the Act was amended.
Presumably it was the Access to Justice Act 1999,
Indeed.
which introduced, I think, the concept of a CFA for the first
Indeed.
time in our procedure. And my recollection, but I could be wrong, is that we did start using the phrase success fee from that time.
From the beginning.
Certainly when I was counsel, I did occasionally enter into CFAs, and I can remember them referring to success fee.
Thank you.
When we go to the rules that are made under Section 51 of the Senior Courts Act, so I'm back in the White Book, Part 44, page 1441.
Sorry, what page is that?
1441. So at 44.1 we do have some definitions. So we have conditional fee agreement, means an agreement enforceable under Section 58 of the Courts and Legal Services Act. Costs includes fees, charges, disbursements, expenses, remuneration, reimbursement allowed to a litigant in person under Rule 46.5, and any fee or reward charged by a lay representative. So fees, charges, disbursements, expenses and remuneration would appear to be what lawyers are in the business of. And then we've got litigants in person and lay representatives. So it's all monies, and certainly would, in terms of that definition, include a success fee within the notion of costs.
And certainly practice was, as I recall, between 2000 and 2012, that success fees were awarded as part
costs.
of the cost order.
Indeed. And they were susceptible to detailed assessment,
Yes.
both as, so the base costs would be the subject of detailed assessment, and then the uplift allowable in terms of a percentage, but also there were occasions where it might be limited in terms of time, depending exactly what had happened. And of course, also susceptible to solicitor and own client assessment. So if we continue on looking at Rule 44.2 over the page at 1443, court's discretion as to costs. I'm taking the court to this really to highlight that costs order is not a specific creature. It is a language that is used, but when we look at the rules in relation to costs, they are dealing with all sorts of orders that deal with or impact on costs. So we see the way it's talked about and described at 44.2.1, court has discretion as to whether costs are payable by one party to another and the amount and when they're paid. 2, if the court decides to make an order about costs, which is the broadest description, the general rule is that an unsuccessful party will pay, but the court can make a different order. And at 4, Rule 4, in deciding what order, if any, to make about costs. And so it goes on. There's not a definition in the rules of costs order as a particular species or a particular term of art for a particular type of order that deals with, impacts on, is about the costs that have been incurred in proceedings. And so coming straight back to your Lordship's question, when we look at section 58A, which ruled out the recovery of a success fee, the uplift, from another party in litigation, by that language, a cost order in proceedings may not include, we would invite the court to conclude that a cost order is simply an order that is about, that deals with, that addresses costs in proceedings. And in those circumstances, in terms of a stand-back analysis, first of all, the idea that you take an uplift and you make it in an Inheritance Act claim part of an award, when you could not make it part of, I'll say, an explicit order about costs, does not sit with Parliament's decision as expressed in section 58A. But actually, in our submission, it's completely contrary to it. The fact that an order deals with things in addition to costs would not strip it of the fact that it was an order that was about costs, a costs order. It's not exclusively about costs, but it's still dealing with costs. If you put it in the Inheritance Act position, if you had an award that was solely about the transfer of property, a home, or the giving of a life interest, and then made a money order that was just confined to addressing an uplift, that in our submission would be no different than the order that happened here, where the different bits of the award are put together. Either way, it is an order that is about costs. It might not only be about costs, but it is about costs. And so it can accurately be described as a order, a costs order, and one that therefore falls foul.
So can I ask you this? Suppose the judge had not been dealing with the uplift element, but was alive to the realities of life, that this lady does in fact have a costs bill that she's going to have to pay to her solicitor.
In terms of the base costs.
Yeah. If you just use the example of base costs, would you have any objection as a matter of law to the judge in effect allowing an element for that base cost liability, because living in the real world, the judge knows that if I don't allow her this element or some part of it, she will in fact not have enough to live on. So therefore, it will have an impact on what I'm trying to achieve, which is to make reasonable provision for her daily living expenses.
My lord, what we would say is that the judge could not make that an award and therefore circumvent the checks and balances that exist around the shifting of one party's costs to another. If a court makes an order that, putting the uplift to one side, makes an order that X pays Y's costs, then that is susceptible to detailed assessment, etc. And there is a whole regime in Part 44.
Right. That answer suggests that actually the primary basis for your submission is not in truth Section 58A. It's a more general proposition.
It's 2 points.
I see.
So far as the uplift is concerned, that is not lawful, and the fact you disguise it within an award does not change that. So far as the including costs in an award, rather than making an order which everyone can see and everyone accepts, has to go through the usual processes for costs, either summary assessment or be sent off for detailed assessment, then we say that would apply whether you're talking about costs outside a CFA, base costs, or uplift on a CFA.
But what do you say to my suggestion that would leave the judge having to behave in a way which just isn't real? Because he would know that although I've made this award, in fact, this person is not going to be able to afford to live, because what I award is in reality going to be eaten up by her debts to her solicitors.
My lord, as a matter of principle in civil litigation, Part 44 applies where one party is being ordered to pay another party's costs, and the winning party will generally get their costs, but they do not get 100%. The processes that are checks and balances so that a party is not free to reach whatever agreement it likes with its lawyers and pass that on to the other litigant, albeit that they're unsuccessful, are there and clear. And our submission would be you cannot avoid those processes by ignoring CFAs and uplifts, simply saying, well, I'll make an award that covers the costs and then be silent. You know, I don't need to make an order that says X pays Y's costs because I've put it in the award.
So if I can just, for a moment, ask you this, because I have been concerned, because I've been thinking of the analogy to financial remedy cases. Because it is not uncommon, it's not routine, but it's not uncommon in a needs case for a court to make an order which will accommodate, if not all, a significant portion of the costs on the basis that without that their needs will not be met. But hearing your submissions, it occurs to me that you might be saying that the reason that that's permissible, although not encouraged, but permissible in financial remedy proceedings, is that the rules say that costs lie where they fall, and before a costs order can be made, you have to establish litigation misconduct. Whereas you would say in civil proceedings, that safety net, if I can call it that, to protect needs, because this is a needs case, is not necessary because there is a presumption that costs follow the event.
Indeed.
And actually, if it turns out that when the offers are disclosed, you don't get your costs, well, that is one of the penalties of the more rigorous process that there is within the civil procedure.
Indeed.
Does that work?
Yes, it does. And it really highlights the point. It is hard to see why, if the respondents are right and it is possible for the court to lift the uplift out of any cost regime and put it in the award, why, what is it that stops litigants doing that with the base costs, the ordinary costs in a non-CFA case? In civil proceedings, not only are there the checks and balances of the court having to make a decision whether to summarily assess or send it off for detailed assessment, deciding whether to have it on a standard basis or an indemnity basis. Those are checks and balances. You have the cost shifting. You will normally recover your costs if you've been successful, but the checks and balances make sure, aside from the specific merits of the case, which may lead the court to making issue-based, etc., that the amount is not excessive. There is a whole regime that is about that amount. But there is another problem. If it is possible to do as the respondents suggest and take what are actually costs out of being seen and treated as costs and a cost order dealing with them, is what do you do about Part 36?
Well,
Part 36 cannot work if there is the option for the court to treat what is in truth costs as if it is not. How do I, as a defendant, make a Part 36 offer? Because we don't have uplifts being recoverable anymore, we no longer have the requirement that a litigant entering into a conditional fee agreement has to give notice to the other party that there is one. So I, as a defendant, may not even know there's a CFA in place. I'm certainly not going to know what the percentage is on it. If there is a chance that the court may, at the end of the day, recast what in truth are costs as an award, how do I make an offer in respect of that award when I don't know there's a CFA and I don't know what the percentage is? And then what happens in terms of I've made an offer which I then fail to beat because the award is put in, the what are in truth costs are put into the award and miraculously no longer become costs. But then I'm subject to an order that I pay not only that sum, which in truth I would have beaten if it hadn't been, the award hadn't been enhanced by what in truth it costs, and I have to pay the costs of the litigation, but what are the costs? I mean, it just breaks down completely.
Is that inevitable? I'm sorry, I can't remember exactly how Part 36 operates. Is it always, if you beat the payment in then you succeed? Or is there a discretion? In other words, is it possible under 36 that a judge could say, well, you would have beaten them in but for this particular element of the cost, and therefore I'm going to treat it as though you have succeeded, because you weren't in a position to know that. I mean, I don't know whether, in other words, Part 36 gives flexibility, which might account for that.
If the Part 36 offer is accepted in 21 days, the consequences flow. If it is outside of the 21 days, then you do need the permission of the court, so there is some scope for the court to recalibrate.
I just wondered whether it might extend to the court saying, effectively, you've beaten the offer because we're not going to include the uplift when we determine how much.
If your ladyship and your lordships conclude that's the world we're in, where costs are no longer costs and they're an award, then
that's a different
I anticipate we will be litigating that one out as to whether that is an appropriate factor for the court to take account of and when it can actually assist. But it still leaves a litigant, a defendant, having to judge their offer, which is required under the rules to be an offer of a single figure. And I can take you to that. It's on page 1279 of the White Book. 36.6.1, defendant's offer. A Part 36 offer by a defendant to pay a sum of money in settlement of a claim must be an offer to pay a single sum of money. So I can't say this much for all these other bits of the award, and if your costs are coming in an extra bit. I have to pin my colours to the mast in terms of making the offer in a situation where costs which should be not a part of that offer might become it. Might become part of it.
And then you have the risk that if the judge makes the award for the uplift, and then when the offers come in,
I've undershot it.
you've undershot it, then, and so there's no award of cost, they're still stuck with the uplift. So they've still got that portion that's gone towards their, if I can mutually call it, their legal representation, that they have to pay by virtue of part of the award.
When I didn't know there was a CFA and could possibly be an uplift.
And so if you then started saying, could you make it contingent, that absolutely plunges into how could you call it anything other than costs if you make it contingent on whether there's a cost order made.
Is there a power in law to make any part of the award under the 1975 Act conditional on some future event?
Give me one moment with that.
No, by all means come back to that question.
Yes, I will do.
But it's a genuine question, because I don't know whether there's legal power to do it in the first place. And then secondly, is my lady's suggested difficulty that it might be a problem if you were doing it in this particular context anyway.
And there is an ability to create trust and things. So there might be a device through which you could do it, but there's not an explicit make it subject to an event.
Your fundamental submission is that costs means costs, and it's substance, not form, which matters, and that it's quite clear when you interpret the legislation that it should not feature as an element of an award under the 1975 Act. That's really your simple submission, isn't it?
It is. It is.
I'm not saying it's right, but just want to understand that's what it is.
And the costs are costs, and a costs order is an order that deals with something which has been the costs of proceedings, and that an award has to be, in a non-spousal case, has to be determined by reference to reasonable financial provision, and that has to be maintenance.
And do you also, I just want to see how you put the submission, so I've understood it correctly. I know you make both submissions, but do you need to succeed on your broader submission Or could you succeed simply if your narrower submission is correct? Your narrower submission is
Either one will get me home.
look at section 58A, which is specifically about uplifts, and that is definitely prohibited, and you can't get, you say, I think,
Indeed.
on the narrow submission, you simply can't bypass the statutory bar.
By recasting
Yeah.
or hiding, I would say, the costs in an award.
And that's enough for you to succeed on this
Indeed.
ground of appeal, is it? I
Indeed.
see. Yeah.
But your section 58 argument, I mean, in a sense, that gives the argument to the other side as well, doesn't it? Not say you're wrong on it, but it's because it's not recoverable in the costs. That is an expense which is actually incurred and which creates a need which otherwise would be met by the costs award, but it's not being met by the costs.
Indeed. So that is why they
that's
can
really the
say it's
issue
a
we have to
financial
decide.
need for the purposes of Section 3.
Yeah. I mean, if it were recoverable under the costs award, then it oughtn't to be need, because if they've acted properly, they get the money back.
Indeed. Or, well, but
Not
again, they wouldn't get
They
100% of the
I
money.
understand. I understand.
And that rather demonstrates that its costs, it doesn't morph into an award.
You say it couldn't be right for a judge to say, for example, well, you know, you normally don't get more than, let's say, 80% of your costs back. So I'm going to give you 20%
As your
on the
award.
basis that you're going to have to pay. And that's a need that you will have to meet. And so you say it must be the same here in principle.
Indeed. If I can then come back to the Inheritance Act point and take you to ILOT. Which is the first authorities bundle divider 11. Page 249. The very bottom of the page, judgment of Lord Hughes. The paragraph I took you to earlier. Third, so the key features of the operation of the Act. Third, all but spouses who are in a relationship at the time of the death can claim only what is needed for their maintenance. Then maintenance is dealt with at length from page 255, paragraph 12 in Lord Hughes' judgment. He says, the concept of reasonable financial provision is thus, by the closing words of section 1, subsection 1, made central to the jurisdiction to depart from the will and intestacy rules as the case may be. And at the last sentence of that paragraph over the page, in the case of all other applicants, section 1(2)(b) makes it clear that reasonable financial relief provision means such provision as would be reasonable for the applicant to receive for maintenance. He continues, this limitation to maintenance provision represents a deliberate legislative choice and is important. Then goes through some of the history of its consistent feature. And at paragraph 14, the concept of maintenance is no doubt broad, but the distinction made by the differing paragraphs of section 1, subsection 2 show it cannot extend to any or everything which it would be desirable for the claimant to have. It must import provision to meet everyday living, the expenses of living. And he refers to Jennings. The claimant was an adult son living with his family in comfortable circumstances on a good income from 2 businesses. The proposition that it would be reasonable provision for his maintenance to pay off his mortgage was correctly and firmly rejected. and then quoting from, as he then was, Mr Justice Brown Wilkinson at H. The word maintenance is not, sorry, the applicant has to show the will fails for his maintenance. Disapproval of Christie, in which the judge treated maintenance as being equivalent to providing for well-being or benefit. Word maintenance is not as wide as that. The court has up till now declined to define the exact meaning of maintenance, and I'm certainly not going to depart from that approach. But in my judgment, the word maintenance connotes only payments which directly or indirectly enable the applicant in the future to discharge his cost, the cost of his daily living at whatever standard of living appropriate to him.
Is it the word indirectly which may be difficult in this context? Because as I understand it, what the judge was trying to do was to take account of the realities of life.
Indeed. My Lord, if I can put it this way, it is right that the indirect opens up the possibility that, for instance, I do pay off your mortgage because that enables you to save the cost if you're then thrown out of having to pay your rent, which clearly would be maintenance. What in our submission it doesn't open is the idea that it's money to pay off any debt that you can't afford to pay. That is, what is being required is some connection to a living expense. So the examples we see, and I won't, because of time, take you through all of them, but it runs through to the end of paragraph 15, and then we see some more of it at paragraph 18 and 19. Each time it is, even if it is indirect, it's related to the provision of housing.
Yes, I see.
To the ability to continue your business so that you can earn your living. So there has to be not just the need and not just a liability, but the one that is, whether it's direct or indirect, related to income.
Yep.
And as the courts make clear, that doesn't mean you can't address that by a capital sum, but it still has to feed income and daily living expenses in some way.
Yeah, otherwise, you say...
Otherwise, any debt,
any capital sum, and there would be no limitation, which is contrary to Parliament's will.
Indeed. And what the courts are clear, the maintenance isn't just about a standard of living, because we have this language around living expense, your expenses, it being directly and indirectly connected. So the introduction of maintenance serves two purposes. One, and it's individualised, what the standard is, you don't get to live in luxury, but also what it directly or indirectly connects to. I think that probably makes the point. And if I break there, and I will just check if there are a couple of things I need to sweep up after lunch, but certainly being no more than 5 minutes.
Well, that might be sensible in any event if we rose now and let everyone have a bit of a longer break.
I'm great.
Very well. 2 o'clock, please. Thank you very much.
Right.